If you're a veteran, you know the struggle. You served your country, you came home with injuries, visible or invisible, and now you're navigating the labyrinth that is the Department of Veterans Affairs. It's supposed to be a lifeline, but often it feels like a battlefield all its own. And because the system is so complex, so frustratingly slow, a whole industry has sprung up promising to help you. These are the VA helpers, the consultants, the companies that claim they have the secret sauce to unlock your benefits. Some of them are legitimate, accredited professionals who genuinely want to see you succeed. But far too many are predatory actors, snake oil salesmen looking to exploit your trust, your desperation, and your service-connected condition for a quick and often illegal payday. They use jargon, they use fear, and they use the fact that you're tired of fighting the system to draw you in. We're here today to arm you with the knowledge you need to fight back, to protect your benefits, and to ensure that the only people who profit from your service are you and your family. We are cutting through the noise and giving you 20 critical, non-negotiable tips that every single veteran needs to know before signing a single piece of paper or sharing a single bit of personal information with anyone claiming to be a VA claims expert. This is about securing your future and stopping the scams before they even start. Let's dive straight into the first, most crucial point, the foundational knowledge that should be the first question you ask any potential helper. Tip 1. Demand proof of VA accreditation right now. This is not a suggestion, it is the law. The Department of Veterans Affairs has strict rules about who can legally charge a veteran money for claims assistance. They must be accredited by the VA's Office of General Counsel, OGC. This accreditation means they have passed character and fitness tests, they have received mandatory training, and they are held accountable to federal standards. If a company, consultant, or individual tells you they can help you increase your rating, file a new claim, or handle your appeal for a fee, and they cannot immediately provide their OGC accreditation number, you need to walk away immediately. It doesn't matter if they are a veteran themselves or if they have 1,000 testimonials. If they are not accredited, they are practicing law without a license in the VA context, and their operation is fundamentally illegal. They might try to skirt this rule by saying they are only consulting or coaching, but if the service involves preparing, presenting, or prosecuting a claim for benefits, accreditation is mandatory if they are charging money. A common tactic is for unaccredited firms to hire a single accredited agent or attorney to rubber stamp thousands of claims, creating a massive conflict of interest and diluting the quality of representation. Always verify the individual you are working with, not just the company. If they hesitate or offer excuses like, "It's pending," or "It's not necessary for our type of service," that is a massive, immediate red flag, signaling potential fraud and unauthorized practice. Protecting yourself starts with this basic verification step, ensuring that the person handling your life-changing benefits is legally sanctioned and professionally accountable. This accreditation process is designed specifically to protect you, the veteran, from unscrupulous actors who have no legal obligation to act in your best interest. Now let's talk about the money, which brings us to Tip 2. Understand the fee structure and the illegal contingency trap. This is where the vast majority of scams operate. VA-accredited agents and attorneys are allowed to charge fees, but these fees are strictly regulated. Crucially, they cannot charge you anything for initial claims. 0. It is illegal for them to charge a fee for the preparation or presentation of an original claim for benefits. Fees are only permissible after the VA has issued an initial decision, and usually only in the context of an appeal or a claim for increased benefits. Furthermore, the standard legal contingency fee, where they take a percentage of your back pay, is typically capped at 20% to 33.3%, and usually only applies to the back pay recovered, not your future monthly payments. The scam artists, however, often demand 4, 5, or even 6 times your monthly benefit as a fee for their consulting services, often disguised as a flat rate or a success fee that is explicitly tied to the outcome of your claim. They call it a coaching fee or a document review fee to avoid using the word contingency. But if the payment is dependent on the VA granting you benefits, it is an illegal fee structure for an initial claim. If a company demands a percentage of your future monthly benefits or a lump sum payment that far exceeds the standard 33.3% of back pay, especially for an initial claim, they are operating outside the law and are setting you up for financial disaster. They rely on the fact that you don't know the rules. Demand a clear written fee agreement that explicitly states the fee is only for services rendered after the initial decision and is based only on back pay. If they refuse, or if the contract uses vague language about consulting, run. This financial protection is paramount to ensuring that the benefit you earned actually stays with you. Moving on, let's expose the myth they all sell you with. Tip 3. There is no secret sauce or magical rating formula. If a helper promises they have a proprietary system, a secret contact inside the VA, or a unique process that guarantees a 100% rating, they are lying. The VA rating schedule is codified in Federal Regulations 38 CFR, and it is publicly available. The process is based on medical evidence, service connection, and the severity of your symptoms, not on a clever trick or a special form. Scammers use the idea of a secret sauce to justify their exorbitant, illegal fees. They suggest that the accredited VSOs or attorneys are too slow or don't know the new loopholes, which is simply false. What they are actually selling is often just highly aggressive filing, sometimes encouraging veterans to exaggerate symptoms or file claims that lack merit, which can ultimately harm your credibility with the VA and lead to long-term problems. A legitimate representative works with the facts, helps you gather strong medical evidence, and clearly articulates the connection between your service and your disability. They don't rely on magic or manipulation. When someone tells you they have the guaranteed path to 100%, they are selling hope and exploiting your desire for resolution, not providing competent legal assistance. The best secret sauce is meticulous preparation, accurate medical documentation, and patience, things a legitimate representative will provide without the need for fraudulent promises. This leads directly to Tip 4. Distinguish clearly between VSOs, accredited agents/attorneys, and unaccredited consultants. These three groups operate under vastly different rules and ethical standards. Veterans Service Organizations, VSOs, like the DAV, VFW, and American Legion are free. They are accredited, they are trained, and they are generally excellent resources for initial claims. They cannot legally charge you a dime. Accredited agents and attorneys are also accredited by the VA, but they can charge fees, usually for complex appeals or claims for increase, and only after the initial decision. They are bound by professional ethical rules and the VA's fee limitations. Then there is the third group, unaccredited consultants. These are the scammers. They are usually former veterans or former VA employees who have not sought or maintained OGC accreditation. They operate in a legal gray area, or outright illegally, by claiming they are merely coaching or advising. They have no regulatory oversight, no ethical obligations, and often charge the highest, most egregious fees. Never confuse the free accredited VSO help with the fee-based, unregulated consultant help. If someone is charging you, they must be an accredited agent or attorney, period. Understanding these distinctions is your shield against those who hide behind vague titles and military jargon to legitimize their non-accredited status. The next tip is a massive warning sign that should stop any transaction immediately. Tip 5. Red flag, any guarantee of a specific rating or outcome. If a helper guarantees you a 70% rating, a 100% rating, or promises that your claim will be approved within a certain timeline, they are engaging in misleading and potentially fraudulent behavior. No legitimate representative, not an attorney, not an agent, and certainly not a VSO, can guarantee the outcome of a VA claim. The decision rests entirely with VA raters, based on the evidence presented, the C&P exam findings, and the application of federal law. Anyone who guarantees a rating is either lying to secure your business or encouraging you to commit fraud by exaggerating or falsifying symptoms to meet a specific rating threshold. Legitimate professionals discuss probability and strategy based on your medical records. They never promise a specific number. They might say, based on your evidence, we believe you have a strong case for service connection and a high likelihood of a rating in the 70% to 100% range. But they will always include the caveat that the final decision rests with the VA. The moment you hear the word guarantee in relation to a specific percentage, you should recognize that the person on the other end is prioritizing their commission over your ethical and legal standing with the VA. A promise of 100% is a promise of financial exploitation disguised as assistance. Now we shift our focus to the necessary due diligence, starting with Tip 6. Always check the VA's official OGC database for accreditation. This is the definitive source, and it takes 2 minutes. Do not trust a screenshot of a certificate they send you. Go directly to the VA's Office of General Counsel website and use their search tool to look up the individual's name or the law firm's name. This search will confirm their status, whether they are an attorney, an agent, or a VSO representative, and crucially, whether their accreditation is active and in good standing. If they are not listed, or if their status is suspended or expired, they cannot legally charge you for claims assistance. Scammers often use slightly altered names or claim to be affiliated with a legitimate firm when they are not. Cross-referencing the information is non-negotiable. If you cannot find them on the OGC website, they are operating illegally, and engaging their services puts your entire claim at risk, potentially leading to the VA rejecting the submission or worse, opening you up to an investigation for unauthorized representation. This step is the concrete verification that separates the legal helper from the fraudulent one. You must be the one to verify, as they have a vested interest in concealing their lack of credentials. The next point addresses a major tactic used by legitimate, fee-based representatives, but also exploited by scammers. Tip 7. Scrutinize the request for power of attorney, POA. When you hire an accredited representative, an agent, or an attorney, they require you to sign a VA Form 21-22, Appointment of Veteran Service Organization as representative, or 21-22A, Appointment of Individual as claimants. Representative. This grants them power of attorney, allowing them to legally act on your behalf, review your file, and submit evidence. While this is standard practice for legitimate representation, unaccredited consultants often try to get veterans to sign vague, consulting agreements that grant them access to records without formal POA status, or they push for the POA even though they are not accredited to receive it. If an unaccredited company asks you to sign a document that gives them control over your claim submission or access to your C-file, they are crossing a legal line. Furthermore, understand that signing a POA gives that representative significant control. If you become unhappy with their service, you must formally revoke the POA, which can sometimes slow down your claim. Never sign a POA lightly, and never sign one with an individual or company you haven't thoroughly vetted via the OGC database. If the helper insists on a POA but isn't listed as an accredited representative, they are either attempting fraud or setting up a shell game where they use the POA to control your claim while outsourcing the actual filing to a minimally involved accredited party, maximizing their profit while minimizing their responsibility to you. Let's look at how they build trust, which is often through fabricated social proof. Tip 8. Be skeptical of overly enthusiastic or vague testimonials. Every scammer has a wall of positive reviews. Look closely at the testimonials presented by claims consultants. Are they vague, using phrases like, "They got me what I deserved," or "the best help I ever had," without specific details about the condition, the timeline, or the legal process involved? Are the people giving the testimonials verifiable veterans? Many fraudulent. Operations use stock photos, fake names, or pay actors to provide glowing reviews. Legitimate law firms and accredited agents often have detailed case summaries, with permission and privacy maintained, or reviews on verifiable third-party legal platforms. If a company's entire marketing strategy revolves around flashy, emotional testimonials promising life-changing wealth and immediate 100% ratings, and they lack clear, substantive legal or medical case studies, treat it as a massive warning. The focus should always be on the process, their legal strategy, medical understanding, and ethical handling of your case, not just the promised outcome. When evaluating reviews, look for transparency. If the review seems too good to be true, or if the reviewer's identity is suspiciously generic, assume it is fabricated to manipulate your trust. Now, let's talk about the binding document. Tip 9. Have any contract reviewed by an independent accredited professional. Before you sign anything, whether it's a POA, a consulting agreement, or a fee agreement, you must understand every single clause. These contracts are often designed by the consultant's lawyers to protect the consultant, not you. They may contain clauses that mandate arbitration, preventing you from suing them in court, require payment regardless of whether the VA ultimately approves the claim, especially common with unaccredited firms, or grant them rights to your medical records far beyond what is necessary for the claim. The most insidious contracts are those used by unaccredited consultants that try to structure the fee as a loan or a purchase of services to mask the illegal contingency fee. They will demand a massive lump sum payment upon success, arguing it is not a fee for representation, but a fee for coaching. If you are considering working with a fee-based service, spend a small amount of money to have a separate, accredited VA attorney review the contract before you commit. This third-party review is an investment in your financial security, ensuring you aren't signing away future benefits or agreeing to illegal fees that will be nearly impossible to recover later. Never feel pressured to sign on the spot. A legitimate company will always give you time to review the documents thoroughly. Pressure tactics are a hallmark of the scammer playbook, leading us to Tip 10. Recognize and resist high-pressure sales tactics and artificial urgency. Scammers often operate like timeshare salesmen. They will tell you that the window of opportunity is closing, that the rules are about to change, or that they only have 3 spots left this month for their exclusive service. They use scarcity and urgency to prevent you from doing the necessary due diligence, like checking their accreditation or reviewing the contract. A legitimate representative understands that your VA claim is a serious, often life-altering legal process that requires careful consideration. They will encourage you to take your time, gather your thoughts, and ensure you are comfortable with the arrangement. If a helper is calling you repeatedly, demanding an immediate decision, or offering a special discount that expires within 24 hours, treat it as an immediate and severe red flag. This behavior is designed to bypass your rational thought process and push you into an emotionally driven decision, which is precisely how they secure illegal contracts before you realize the implications. Your benefits are not a limited time offer. Take the time you need. Now, let's talk about protecting your digital and personal security, starting with Tip 11. Never share your VA.gov or e-benefits login credentials. This is an absolute security breach and a massive risk to your identity and your benefits. Your login credentials are the keys to your entire VA record, your medical history, your payment information, and the ability to change direct deposit details. No accredited representative, attorney, agent, or VSO needs your password. They gain access to your file legally through the POA process, Form 21-22 or 2122A. If a consultant asks you to provide your username and password so they can check your file faster, they are bypassing the legal VA process, which is a massive violation of security protocol and potentially illegal access to federal systems. Sharing your login information exposes you to identity theft, financial fraud, and gives the scammer the ability to file claims or appeals without your direct knowledge or consent, which could jeopardize your future eligibility. Protect your digital identity as fiercely as you protect your bank account. Only use the official VA process for granting access. Any request for your password is an immediate sign that the helper is operating outside of legal and ethical boundaries. This ties into Tip 12. Maintain control and ownership of all your medical records. Your C file, your private medical records, and your service treatment records, STRs, are your property. A legitimate representative will ask you for copies or request them through the VA, but they will not try to take exclusive ownership or prevent you from accessing them. Unaccredited consultants often demand that you send all your records to them, sometimes claiming they need to translate them or optimize them for the VA. This is often a tactic to centralize control. If you decide to fire them later, they may hold your records hostage or charge exorbitant fees for their return, effectively crippling your ability to move your claim to a new, legitimate representative. Always keep the original copies of all your documentation. When you provide records to a helper, provide copies only. Ensure you have a clear understanding of how they store and secure your sensitive medical and personal information. If they are storing hundreds of veterans' C files on unsecured servers, you are at risk of a massive data breach. A transparent representative will be clear about their data security protocols. A scammer will try to hoard your data to maintain leverage over you. Let's discuss the core medical requirement for most claims. Tip 13. Understand the nexus letter process and who should be writing it. A nexus letter is the crucial piece of medical evidence that links your current disability to your military service. It must be written by a qualified medical professional who understands VA disability criteria and, most importantly, must state that it is at least as likely as not, 50% or greater probability, that the condition is service-connected. Scammers have turned the nexus letter into a profit center. They often use shell companies or referral services that connect veterans with doctors who charge thousands of dollars for a template letter, sometimes without ever conducting a proper medical examination or detailed record review. These nexus mills often produce generic, non-specific letters that the VA may ultimately disregard, meaning you've wasted thousands of dollars. A legitimate accredited professional will guide you on what evidence is needed and how to find a doctor who can conduct a thorough, unbiased review. They will not sell you a prepackaged letter. Be wary of any consultant who mandates using their specific in-house doctor for a high fee. This often indicates a kickback scheme and a compromised medical opinion. Always verify the medical credentials of the doctor writing your nexus letter and ensure they are conducting a personalized review of your unique history. Here is a simple yet powerful action you should always take yourself. Tip 14. Always file your own intent to file, ITF. The intent to file, VA Form 210966, is the document that establishes your effective date, the date from which the VA calculates your back pay if your claim is approved. It gives you up to 1 year to gather evidence and submit your formal claim while preserving that earlier date. Never rely on a third-party consultant, especially an unaccredited one, to file your ITF. File it yourself immediately through va.gov. If a consultant delays filing the ITF or claims they will handle it as part of their package and they later fail to file it or file it incorrectly, you could lose months or even a full year of back pay, costing you thousands of dollars. Filing the ITF takes 5 minutes, and it is the single most important action you can take to protect your potential benefits. Maintain absolute control over this crucial date. If a consultant tries to dissuade you from filing it yourself, claiming they need to optimize the timing, they are potentially trying to control the back pay date for their own financial benefit. Understanding the complexity of the VA system is key to recognizing when you are being overcharged. Tip 15. Know the difference between an initial claim and an appeal. As established in Tip 2, fees are generally illegal for initial claims. Fees are legally permitted for appeals after the initial decision and for claims for increased rating. Scammers often try to frame a new claim, even a claim for a new condition, as an appeal or a reopening of a previously denied claim to justify charging a contingency fee. You need to understand the VA's Appeals Modernization Act, AMA, and the various avenues: supplemental claim, higher level review, board appeal. If you are filing a brand new claim for a condition never before submitted, it is an initial claim, and no fee should be charged. If a consultant insists that your new claim falls under the umbrella of a previous denial to justify a massive fee, seek a second opinion from an accredited VSO or attorney immediately. Misclassification is a common tactic used to illegally extract fees from veterans who are simply trying to get service connection for a condition they haven't filed for before. If you realize you have been scammed, immediate action is required. This brings us to Tip 16. Report unauthorized practice and illegal fees immediately to the OIG and VA OGC. If you discover that the person charging you money is not accredited, or if they charged you an illegal fee for an initial claim, you have a duty to report them to protect other veterans. The two primary bodies are the VA Office of Inspector General, OIG, and the VA Office of General Counsel, OGC. The OGC handles the accreditation and professional conduct of VA representatives, and the OIG handles fraud and criminal investigations related to VA benefits. Do not rely on the scammer's promise to refund the money or fix the situation. Document everything: contracts, emails, payment receipts, and any correspondence, and file a formal complaint. These reports are crucial for shutting down illegal operations that prey on the ASTA veteran community. Ignoring the fraud allows it to continue, potentially harming hundreds of others. Taking action is part of the commitment to integrity you upheld during your service. If you signed a fraudulent contract, there are still avenues for relief. Tip 17. If you signed an illegal contract, it may be voidable. If you signed a contract with an unaccredited individual for claims assistance, or if the contract demands an illegal fee, like charging for an initial claim, that contract is likely voidable under federal law. The law is designed to protect veterans from these predatory agreements. If you realize you are trapped in a contract, seek immediate legal advice from an accredited attorney who specializes in VA law or consumer protection. Do not try to negotiate with the scammer yourself, as they will use legal jargon and intimidation tactics. In many cases, an accredited attorney can help you void the contract, recover any money already paid, and potentially file suit for damages. The key takeaway here is that signing a bad contract does not mean your benefits are permanently compromised or that you are financially obligated to pay an illegal fee. The law is on your side, but you need professional accredited help to leverage it. Understanding the limitations on legal fees is essential for long-term protection. Tip 18. Be aware of the one-year rule for legal fees in appeals. Even when working with an accredited attorney or agent on an appeal, there are regulations regarding when they can start charging fees. Generally, fees for representation are only permitted after a notice of disagreement, NODI, has been filed, or after the VA issues the initial decision. Furthermore, the law specifies that for an appeal, the fees generally cannot be collected until after the one-year period following the initial decision has passed, unless a specific fee agreement has been approved by the VA or is otherwise compliant with the law. Scammers often ignore these time constraints, demanding payment immediately upon a successful rating increase, regardless of the timeline of the appeal or the specifics of the case. Always verify the timing of the fee collection against the VA's regulations. If the contract demands immediate payment for a decision that is less than a year old and was not formally appealed through the proper channels, question the legality of the demand. While federal law governs the VA, state laws offer additional protection. Tip 19. Utilize state-level consumer protection and unauthorized practice of law statutes. Beyond federal VA regulations, most states have powerful consumer protection laws that prohibit deceptive trade practices. Furthermore, every state strictly regulates the unauthorized practice of law. Since assisting veterans with VA claims for a fee is considered the practice of law, unaccredited consultants are often violating state criminal and civil statutes. If you are scammed, you may have recourse through your state attorney general's office or local consumer protection agencies. These state bodies often have more resources and faster response times than federal agencies for recouping lost funds or shutting down local operations. Do not assume that because the claim is federal, the fraud is purely a federal issue. State laws can be a powerful tool to recover damages and penalize those who exploit veterans within their jurisdiction. Consult with a local accredited attorney to determine if state-level action is warranted. Finally, the most powerful tool you possess is your own judgment, which brings us to Tip 20. Trust your gut and be prepared to walk away. If something feels off, if the promises are too grand, the fees are too high, the pressure is too intense, or the paperwork is too confusing, listen to that inner voice. Veterans have highly developed instincts. Use them here. A legitimate professional will respect your skepticism and will take the time to answer every question thoroughly and transparently. A scammer relies on you ignoring your intuition. The cost of walking away from a potential scammer is zero. The cost of signing with a predatory consultant can be tens of thousands of dollars in lost benefits, legal fees, and emotional distress. If you find yourself in a situation where you are being rushed or discouraged from seeking a second opinion, terminate the communication immediately. There are thousands of ethical, accredited, and highly competent VSOs, agents and attorneys who genuinely want to help you. Take the time to find one you trust, one who operates within the law, and one who prioritizes your well-being over their profit margin. These 20 tips are your armor in the confusing world of VA claims assistance. Remember the core message: your service earned these benefits, and you deserve to keep them. Never pay for initial claims assistance. Always verify accreditation through the OGC database. Never share your passwords. And when in doubt, consult a free VSO or an accredited attorney for a second opinion. The VA system is complex, but by staying informed and demanding transparency, you can secure the compensation you deserve without falling victim to the sharks looking to exploit your sacrifice. Be vigilant, be prepared, and protect what you earned.